there's different statute of limitations for many different factual things involved in the case. So one of the most common questions that we get is, what is my time limit to do something here, or have I waited too long to do something? And generally, the medical malpractice statute of limitations is 2.5 years from the date of the treatment or incident that you're complaining. However, that's just a general statement. It really can differ greatly based upon the type of case it is and who's involved. For example, in a case where a foreign instrument, like a surgical instrument or a sponge, is left inside someone, they may not find that out until 3 years after a surgery. And in that case, the statute of limitations is either 2.5 years from the date of the surgery or 1 year from the date where you discover that it's a problem, whichever is longer. So even though you may think it's beyond the 2.5 years, that case is saved by what's known as the discovery rule. Similarly, in cancer cases, there's a recent change in the law in New York to something similar that gives people 2.5 years from the time when they know or should have known facts that give them reason to believe that there was an error in something along the way that missed a cancer diagnosis, even if it could have happened more than 2.5 years ago. There's also different statutes for different types of treatment depending on the age of the people. For example, if you're under 18, you're not someone who has the legal capacity to even bring a lawsuit. So that's what's called a tolling of the statute of limitations, either until you turn 18, at which time you have 2.5 years to bring a suit, or 10 years at a maximum length from the date of the treatment complained of. The statute's also affected by the relationship that you have with the physician. For example, if you think there was an error in a surgery that occurred 4 years ago, but you kept seeing the surgeon for the issues caused by that, the statute of limitations might not start to run until you stop treating with that doctor. There are also different statutes applicable to different types of entities involved in cases. For example, if you have a state-run facility or a public benefit corporation, like locally Roswell Park or ECMC, there's very short time limits applicable, called essentially a 90-day notice of claim and a requirement that you bring a suit within 1 year and 90 days of the incident. In certain matters involving federal entities like the VA, you have 2 years from the incident to file what's known as a Federal Tort Claims Act. So, to sum up, there's different statute of limitations for many different factual things involved in cases, and you need someone who can talk to you about those facts and that has the knowledge of the New York law that I've been discussing to apply it to the facts of your case to tell you really what the statute of limitations is in your case. So even if you think that you may have missed it, or you're not sure, it's best to just call an attorney to find out.